Is it Mr. Hinchy or Mr. Hinkie? Mr. Hinchy.
No, my name is Barry Lang, Your Honor. I represent Barbara Rudenauer.
Oh, I'm sorry, Mr. Lang. Go. I've got you
Got it backwards here. That's all right. You're all set.
Okay.
Go ahead, Mr. Lang.
Thank you very much. May it please the Court. It's the duty of the Court to construe a statute of repose so as to establish just and reasonable guidelines for different classes of cases. The statute of repose says that it begins to run after the occurrence of an act or omission which is the alleged cause of injury. It doesn't state the date of the occurrence of the act or omission. There are two interpretations to this. Occurrence, as other courts looked at it, applies a continuum. A repeated wrongful acts is a continuum, so that the statute which states the occurrence or act of omission would include this continuum. For where is the actual date of negligence? In this particular case, Dr. Zafiropoulos treated Mr. Rudenauer for an injury to his kidney. The kidney on CAT scans showed what was felt to be a hematoma, a blood collection from an injury. It did not rule out a neoplasm, a cancer. So what did Dr. Zafiropoulos do? He continued to get CAT scans which showed a decreasing size of this, what was felt to be a hemorrhagic cyst at that point, and then followed Mr. Rudenauer in the office on several occasions and got ultrasounds.
You're saying essentially, excuse me, that the doctor has a continuing duty to the patient, am I right?
Oh, a doctor has a continuing duty to the patient while he's treating the patient, but in addition, he has a continuing duty to the patient to follow up with the patient's care, especially if the doctor feels that there may be something still wrong with that patient.
Okay, but why should the continuing duty toll the statute of repose? I mean, the legislature knew about continuing duty, and they wrote a statute of repose.
Well, they didn't address a continuing duty.
Well, doesn't that tell us something that they didn't want? Then they didn't want a continuing duty to affect the statute of repose.
No, the statute of repose mentions it means a date. It means where, at what point can we go back? At what point can a patient sue a physician for negligence? Well, where is that date? It doesn't say, the statute of repose doesn't say a specific date. It says occurrence. An occurrence is when something occurred. So the legislature didn't have to state specifically a continuing duty. By using the term occurrence rather than a specific date, it implies a continuing duty. It doesn't say that we are not going to consider a continuing duty. I submit, Your Honor, that it by stating occurrence rather than a specific date, such as 3 years from the date of negligence, it implies a continuing duty. By recognizing, Your Honor, a continuing duty, it's a course of conduct that was looked at by other states, including sister states such as Connecticut, in several cases.
But the legislature says occurrence of the act or omission. It doesn't say anything about the continuing duty.
Yes, the occurrence of the act or omission. Which act or omission? It doesn't say which act. Is it the first act? Is it the second act? Is it the last act?
Whichever act is the alleged cause of the injury.
But, well, how would Your Honor address the point when there is a continuing course of negligent care, which is the act? There is no one act. If there's negligence in January and negligence in February, which is the act? Where do we draw the line of 7 years? Is it January or February?
Whichever one upon which you base your claim of your cause of action, the claim for the cause of action.
Whichever occurred first.
Well,
January.
Is it whichever occurred first or which occurred last? Because if there's continuing negligence and the last act of negligence continued to cause harm, then that is the occurrence.
In theory, what you are saying is the statute of repose is meaningless because if something doesn't, you can have a 35-year of continuing course of negligent care.
Absolutely, Your Honor. It may seem ridiculous, but that's exactly what I'm saying. A physician has
Did the legislature intend that? That there be,
Well, I
then
think,
there be no
I think they
statute of
did. I
repose?
think they did intend that by stating occurrence rather than a specific date.
Yeah, but they only they did create a specific exception to the rule of repose, and that was leaving the foreign object in the body. They created no other exception.
That's right. And by the plain reading of the statute, they did not exclude continuing course of conduct. Because in my reading of the statute, there is a specific date, which is the last act of negligence in a continuum, because the patient can bring it back to the last act of negligence on which to base his claim.
What is the negligent act upon which you base your claim?
Okay. There are several negligent acts. This is a continuing course of negligent conduct on the part of Dr. Zafiropoulos. Number one,
So you allege in let me just ask you this. He last saw the doctor in 1995?
That's correct, Your Honor.
All right. So do you allege that the doctor was negligent in 1995 and that negligent act caused injury?
Yes, Your Honor. That's correct. But we don't look to that one specific date. We look at the entire continuum of care. A doctor has a continuing duty to notify that patient for follow-up care. What the defendant is saying is that treatment stopped in 1991. There was no follow-up until 1995. There's a period of here of 3.5 or 4 years where there was no contact by the doctor. There's a case in Connecticut, the Sherwood case, where there was a 10-year lapse from the time a blood transfusion was given until the patient was notified that this could contain the HIV virus. There was a duty on the part of the people who gave the transfusion who knew that there was an ELISA test to check the blood to make sure that it wasn't tainted to notify that patient. And it took them 10 years. When the patient found out, it took 10 years, and that was allowed.
Mr. Lang, I mean, your argument has an initial appeal, but doesn't this run counter to the legislature's rejection of the discovery rule?
No.
In other words, you know, in the case that you've just recited, the plaintiff discovered HIV.
Right. The plaintiff discovered HIV 10 years later, but because of the statute of repose would not normally be able to sue back, assume the statute of repose in Connecticut was 7 years.
By rephrasing it as a continuing course of negligent conduct, in other words, you're not pulling every patient back in, you're essentially bypassing the discovery rule, aren't you?
No, you're not bypassing it at all, because the patient still has to bring a lawsuit within 3 years, if it were in Massachusetts, within 3 years from the date of discovery. So if there was a course of continuing negligence, he could bring it back 35 years.
Is this Connecticut case construing their statute of repose?
Yes, Your Honor.
Okay.
Does the legislative history support your position?
Well, if we look to the legislative purpose, the legislative purpose in a statute of repose is to help minimize payments on the part of insurance companies so that there is a date certain that they can set their reserves for, et cetera. They also say that there's a malpractice crisis which they're trying to alleviate by having a statute of repose. Whether there's a malpractice crisis or not, which I personally believe is a political fiction, is time for a different discussion. Nevertheless, assume for the sake of argument, for this argument, that the legislature has a rational purpose for having a statute of repose, and that's to decrease payments and to decrease the exposure of physicians to keep their malpractice costs down. Since the statute of repose, Massachusetts still enjoys the highest per capita physician, of physician population in any state in the United States.
Those are largely irrelevant. I mean, it may what informs you're saying the legislature made the wrong decision. Let me try to do it this way. I'm looking at the language, which is what I have to look to, and it talks about an act or omission.
Yes.
And as far as I can understand it, if for example, in the blood case, I know it's Connecticut, they didn't follow up and test the blood. When should they have followed up and tested the blood?
Well, immediately.
Fine. So they didn't do it immediately. That's when the omission occurred.
No, it occurred on every day, Your Honor, that they failed to do that.
No, it occurred when they didn't do it immediately. Surely I can't have the legislature saying if you have an omission, I mean, otherwise every omission turns into a continuing course of negligent conduct. And that simply means if you act affirmatively, you've got a very clear cutoff date. If you act by omission, there is no statute of repose, because the omission will just continue ad infinitum on every single day.
And our statute of repose says specifically the date of occurrence of the act or omission.
Correct, but what I'm suggesting to you is that the legislature had in mind whatever the first occasion it is that the doctor omitted to do what he or she should have done.
Where, Your Honor, with all due respect, where does it say that? It doesn't. To my reading, and I defer to your interpretation. I mean, you are more experienced than I am in this. But my interpretation is that when does the omission start? We know when the omission ends. It ends when it ends.
Well, I suppose the omission starts and stops when a reasonable physician should have done what it is that is the negligent conduct.
Exactly, which is why the doctor has a continuing duty to correct his error. So how do we see that the doctor here has a continuing duty? Because the doctor knew, Dr. Zafiropoulos knew that this patient could have cancer. How do we know that? This is a factual argument, but we know that because the doctor writes in his notes, no definite mass seen. Well, no definite mass seen is not the same as no mass. The doctor asked Mr. Rudenauer to follow up in a year. It's the doctor's duty to make sure that Mr. Rudenauer followed up in a year.
That's another piece of the argument, which, then goes to, I get a follow-up from my dentist saying, you are due for, or call me in 6 months.
Well, I get a follow-up call from my dentist just to fill a chair for economic reasons. This is even more important than that. The doctor has a duty to follow up with a patient for something not that he doesn't know, but for something that he has a reasonable expectation of finding.
And why has the doctor not fulfilled that obligation when he says to the patient, you should come back and see me within a year?
Because the onus, Your Honor, is on the doctor. What the doctor may not have said to the patient, you must return in a year. He could have said...
Doctor can't make the patient return in a year. If the doctor tells the patient to return in a year, doesn't the patient have some obligation for his own health or her own health?
Yes, but but if you want to stretch that point, then we're looking at contributory negligence. We're not exonerating the doctor just because the doctor may say, you must come back in a year, may say, why don't you come back in a year? What did the doctor tell the patient? That's a matter of fact. The fact is that the doctor has a duty to follow up. When a patient is supposed to come back for a mammogram, the radiologist or the doctor sends notice. When a patient is supposed to return for certain tests, the doctor has a duty to inform that patient. There's another case in Blanchette where the patient had fibrocystic breast disease, and the doctor said basically to the woman who had a lump, don't worry about it. It was the doctor's obligation to make sure, not by the way, come back in 6 months to make sure that the patient actually did. This also, by allowing the statute of repose to include this continuum, to make exception, if you will, for continuing for course of conduct, furthers the legislative purpose. Well, how does it further the...
If I go back to your hypothetical, not clear, that the communication to the patient wasn't clear, come back in a year, the doctor should, you get some expert to testify, should have put a tickler in the file that at the end of the year, if the patient didn't show up. Why wouldn't it be a perfectly reasonable interpretation of the statute to say that's the occurrence? That's the occurrence. 1 year later, if everybody agrees that a 1 year later follow-up was not negligent, that's the occurrence. That a 5 year follow-up is also negligent.
Well, there's a case in New York, Borgia, which basically addresses that. And Borgia states that the breach of duty continues not only after the original wrong, it looks to wrongful conduct even later if that conduct relates to the original condition. So to look at that 1 year follow-up as starting the date of the act or omission, even that would not be proper. Mr. Rudenauer returned in 1995 to Dr. Zafiropoulos with complaints that related to his original condition in 1991, and Dr. Zafiropoulos continued to be negligent by taking ultrasounds rather than a CAT scan. And how do we know that to be true? Because the last ultrasound that he took was just several days before the final CAT scan, and the ultrasound showed a lesion that was about 2 centimeters large. The CAT scan showed a lesion that was 4 centimeters large, which shows that CAT scans are to be used for this purpose. So, because the sensitivity of the ultrasound is not what the CAT scan is. So, according to Borgia, not only was Dr. Zafiropoulos negligent with his course of conduct, but his further negligence even referred back to Mr. Rudenauer's original problem.
I have a fact
Yes.
question. Thank you. I have a fact question. Was the eventual cause of death diagnosable in 1990 and 1991?
Yes, Your Honor.
Is that undisputed?
I don't know that that would be undisputed. It wasn't brought up, but it would be highly unlikely for the same appearing cyst in the same kidney in the same position to have been a different process. This also helps the legislative purpose of
Your red light is flashing, Mr.
Well, let's not
Lang, so your time is up.
Thank you.
Thank you. Mr. Hinchey?
Good morning, Your Honor, members of the Court. Edward Hinchey, representing the defendant physician with Ms. Stacy Morris. If I can reframe the argument for just a moment, somehow Mr. Lang interceded. The defendant in this case is here seeking to reverse a lower court ruling on denying a motion for summary judgment. And I think that's very important because the facts are very finite in this case, Your Honor. And I would suggest that the facts in this medical malpractice case do not bring it within the confines of either continuing treatment or continuing duty issue.
This is Judge Connolly's case?
Judge Fishman.
Judge Fishman.
Oh, this is Judge Fishman's case, okay.
He denied summary judgment for you.
He denied summary judgment
Okay.
for the defendant, and the facts are finite. The facts are in the record appendix. At page 47, there is a specific paragraph 20 that sets out what Mr. Lang's expert was going to say. And all Mr. Lang's expert was going to say was that there were negligent acts occurring in 1990 and 1991. That was the issue presented to Judge Fishman. Mr. Lang, at the hearing on the motion for summary judgment, included a letter from Dr. Sokol, one of his experts, as an attachment to his opposition to the summary judgment motion. And that's at page 56 of the record appendix. And all that letter adds to the already agreed on, and I point this out, Mr. Lang agreed with the defendant's statement that the only allegations of negligence were in 1990 and 1991, was a very vanilla statement that there should have been follow-up. That comes from Dr. Rudenauer's, Dr. Zafiropoulos' own medical record where he says follow-up in 1 year. If we start with that context, the only act of negligence could have occurred by agreement either in 1990 or 1991, or,
At most.
as Your Honor says, the 1-year follow-up, which would have been November 1992. There is no allegation in any fact that there's negligence in 1995. Mr. Lang asserts that, I think, at page 5 of his brief. There is no factual support for that. There is no expert witness that has said that. That is just simply not a matter of fact in this case. The facts in this case are simply that the alleged negligence was the original misdiagnosis. Now, I could digress and point out that the reason he didn't want to do that, perhaps in the underlying case, was that the diagnosis was made in 1995. And to allege negligence in 1995 wouldn't have helped him in the trial of a cancer case in which the diagnosis was made at the same time in terms of the causation.
I assume that part of his argument, if he were to get over this hump, were if it had been diagnosed earlier, there would have been a different outcome.
There's no question that's a part of his argument. There's no question. But there's also similarly no question that the only acts of negligence are, at best, the 1-year follow-up, which would take us to November of 1992, which would be well before the 7-year
So you're saying
statute of
on this
repose.
record, there's no way he can win?
On this record, there's no way that he can prevail on the statute of repose issue, Your Honor.
Well, that's all that's before us.
I believe that is all that's before us, and I just can't understand the argument, frankly, his argument that a misdiagnosis opens up a never-ending statute of limitations.
Well, let's give it the best case analysis, which is the doctor says follow-up. Forget misdiagnosis. Okay, you take misdiagnosis out, but worry, concern. Don't think there's anything here, but come back in a year. And let's assume that we agree with him that it was on the obligation was on the physician to notify, to remind the patient in a year's time. He sends out a notice to the patient. And the patient doesn't come in. That's one hypothetical. Another hypothetical is that everybody agrees that it was reasonable in 1990 for the physician to have told the patient to come back in a year. But the patient doesn't come back in a year, and the doctor does nothing about it. And he gets an expert to say it was negligent of you not to do some follow-up. He didn't do it in a year, but he also did it in 2 years, or 3 years, or 4 years, or 5 years, or 6 years. In other words, where you don't have an act, you have a failure to act. Why doesn't each day that he fails to act, it's getting worse and worse and worse and worse, isn't it?
It certainly is, Your Honor, if in fact that's what the underlying problem is. On the other hand, such a scenario would completely eviscerate a statute of repose. I think the facts have to be that if the expert, and again, as a medical malpractice case, we have to be bound by what the expert says. If the expert says in 1990 you should have followed up, and there's never any follow-up, then the negligent act has to be considered to be 1990. If the expert says you should have followed up in 1 year, and when the patient didn't come back in 1 year, and you should have called the patient then and followed up at that point, then the last negligent act has to be 1992. Or else the statute of repose has absolutely no meaning.
And what if there's no such, you're saying if there's no date, you should follow up in a year. But
No,
what if the expert testimony is you should follow up in due course?
And there is never any follow-up, and the negligence was not in setting up the follow-up appointment. That's a matter of expert testimony. I don't think it's for the court or for me to suggest what the appropriate follow-up in this patient's case was.
I understand that.
It requires the expert to say that in 1990, the plan was we should have followed up in 6 months, or we should have followed up in a year, or whatever the expert says the standard of care required the physician to do at that time. That we don't have in this record. We have none of that. And the premise, if we go back to Your Honor's questions about the follow-up, is that there's a misdiagnosis and that by the follow-up we will catch the misdiagnosis. The Connecticut court in Blanchette that adopted the idea of continuing treatment completely rejected the concept that a failure to correct a misdiagnosis could establish a statute of limitations that was endless because of this exact problem. To suggest now that the interpretation of the statute of repose should graft in a continuing duty or continuing treatment would completely eviscerate what that statute was intended to do.
I'm more interested where the doctor or physician doesn't make a misdiagnosis. Everybody agrees, doesn't make a misdiagnosis, but there's something there. Another possibility, we now know more about inheritance and genetic diseases, and so the doctor takes a long history, does whatever the appropriate scan, highly sophisticated scan, doesn't see anything, but knows that combination of age and genetics, there should be some follow-up. Doesn't follow up. Where do we look for the occurrence? Failure to act.
For the occurrence when the doctor didn't set the initial follow-up. Whenever the date when the doctor made the treatment plan, whether it was to go home.
I can tell you we're going to expose a lot of doctors to a lot of problems if that's your position, because a lot of doctors, in my experience, and maybe this is not, shouldn't be considered, will say you should come back in 2 to 3 years' time.
And that would get us back to when they made that plan, Your Honor.
Well, my concern is that we're putting the obligation on the doctor to make sure that the patient comes back in 2 to 3 years' time.
Well, I'm not doing that, Your Honor, at all.
Okay.
This is all in a medical malpractice case, a matter of expert testimony. If the expert says the physician should have set out a plan, then the physician should have set out a plan. Your Honor's questions almost graft a discovery rule onto the statute of repose, suggesting that there's an underlying genetic disorder that over the course of time will be disclosed. That sounds to me like a discovery rule issue, and of course the statute of repose was intended to be the counterbalance to the adoption of the discovery rule. So it would suggest to me that that analysis has actually been directly rejected by the legislature by adopting the statute of repose. Unless Your Honors have anything further, I would rest on the brief.
Thank you, Mr. Hinchey.